Thank you for joining us for another episode of Condo Insider. My name is Jane Sugimura. I'm going to be your host for this show. And I'm really pleased to have with me as my guest, John Morris, and he's a partner with Ekimoto and Morris LLC. Hi, John.
Hello, Jane.
Hi. Well, why don't you tell the audience about your firm?
Our firm, pretty much all we do is represent condominium and other forms of homeowner association. So uh, we're restricted to mostly that form of practice. We do have some litigation, usually to deal with enforcement or defense, but otherwise we just advise boards of condos and homeowner associations how best to comply with the law.
And you've been doing this for how long?
Uh, I was the state's first condominium specialist in 1988 with the Hawaii Real Estate Commission. So since 1988, I've been working with condominiums and homeowner associations. So I think that's 30 something years.
Yeah. And for a good part of that, you were involved in, and you still are involved with legislation, lobbying
Yes,
for legislation relating to condominiums and community associations.
yes, particularly for condominiums and to some extent communities. So I started doing that while I was with the commission, and I continued after, and I still do submit testimony and sometimes testify on legislation or bills.
Okay, so you're a good person to talk to tell us about. I mean, we're going to be talking about board meetings, and for some reason, there seems to be so many questions about what should happen in a board meeting. And so why don't we start with the statute? The statute is the Hawaii Revised Statute 514 B 125 was it 125A and B,
Yes.
right? That's the
So
one about the board meetings.
yes, and the basic underlying principle, which boards forget or would like to forget, is that the theory of the law is that in almost all cases, the owners associates supervise their board. So the state of Hawaii, when I was the condo specialist, owners would expect us to do that. I was with the Hawaii Real Estate Commission. We don't do that in most cases. In most cases, it's self-governance. The owners are supposed to see what their boards are doing, make sure the board's complying with the law, make sure the board's doing what the owners think is in the best interest. And so the problem for boards is that means that in almost all cases, owners have a right to be at board meetings, to hear what the board is deciding. And in the last few years, they have been allowed to participate directly in the discussion. Up until I think 2 or 3 years ago, the board could vote to, in effect, silence owners and just make them sit there and listen. But a few years ago, the legislature changed the law to say that owners also have rights of participation. So the problem with trying to exclude owners from a board meeting, which is what can happen in executive session, is that the board is not following the self-governance theory of the law, which is board decisions are supposed to be made at a properly called and noticed board meeting at which owners can be present. And that's the basic underlying principle of open board meetings in most cases.
And with the law that changed a few years ago, it said that owners can participate. And I guess that created a problem because the board also has an agenda
Yeah.
that is set by the board president and members of his board. And they need to get through this agenda in order to complete board business. And so when the law was changed, so now boards have to now deal with owner participation. Was there some kind of mechanism or a provision put into the a statute that allowed the board some discretion in limiting that the owner's participation in these open meetings?
The change in the law that said owners cannot be prevented from participating said that the board can adopt rules, and we have a standard form of rules. Many associations already have them. The board can adopt rules to not prohibit, but to control owner participation. So, for example, there's a question of whether they can force owners to just speak at a owners forum. The way the law is written, it's fairly clear that owners can speak as the meeting progresses, as a topic comes up, but most board owner participation rules have a time limit on owner statements of 1 or 2 minutes. They allow the board to say, look, you're just repeating what the other owner just said. We don't want to listen to all that again. We're going to have to cut you off. It's basically a mechanism for the board to try to control owner participation. So they can control, they cannot prohibit. And there's always a question of whether, if their rules are too drastic, they might be considered a prohibition rather than control. But that's why the law actually says the board is supposed to adopt rules. If they fail to do so, then there's an argument that they cannot control owners because that's what the rules are supposed to be for.
So when do the owners find out about these rules?
Well, the statute is actually quite specific. It suggests that after every new board, I guess after the annual meeting, when a new board or different directors or the same directors are elected, they're supposed to publish their rules or reaffirm the existing rules, I guess you could say. But that's part of what the board is supposed to do, to let owners know the terms under which they can participate in board meetings.
Okay, so basically the purpose of these board meetings is to conduct board business, but also to allow the owners to listen and participate, and probably contribute some information, including their perspective as you know,
Yeah.
as an owner, to the discussion that's being had by the board.
Yes, I think that's a very valid point, that we tell boards it's not all just law, it's also politics. If you try and exclude all the owners, you may be missing issues of concern. And of course, the owners are supposed to be there to make sure that you as a board are doing what you should be doing in a reasonable, careful way. But you're right, the part of the process is listening to the owners, because sometimes owners have an area of expertise that can be helpful, but at least at a minimum, they let the board know, so the board's not operating in a vacuum. They let the board know what the owner perspective is on what's going on. Like, I had a board meeting. The question was about controlling parking and what the owners were complaining about the board doing. So it helps the board in many ways to have owners there to give them feedback on how what the board is doing appears to the owners.
Yeah, and as part of the board meeting, there is there comes a time when the president will, after they finish their agenda, will adjourn the public meeting and tell the owners, send the owners off, and they will adjourn and to executive session. Explain
Yes.
to our viewers what executive session is.
Well, it's supposed to be the discussion of a limited number of issues that are considered to either be confidential or to allow the board to have a free and frank discussion without creating liability for the association or perhaps disclosing items. So, for example, one of the categories for which the board can adjourn into executive session, and they are supposed to say why they're going into executive session. One of the categories is litigation. So say the board has to discuss a lawsuit the association's bringing or that's being brought against the association. Purpose of allowing that to be done in executive session is to allow the board to get a full understanding of the case without anyone else being able to know what they're being told. So if the association attorney is saying you have a terrible case, you're likely to lose this, it's probably not the type of information that the board wants to be spread around the general public, because of course it would get back to the opposing parties. So that's one topic. Litigation, personnel, mainly discussing employees, although there is an argument that in a volunteer organization like an association, personnel can include volunteers. Like, say there's a committee the board is appointed, which may be going off the rails a bit, and the board wants to discuss what to do. There's at least an argument that the board could discuss that in executive session, because they want to have a full and frank discussion of what's going on. But typically, executive session, when they're discussing personnel, it's more to do with employees, possibly the managing agent, possibly contractors, but mainly employees. So that's the personnel. And then, of course, as I just explained, if they're getting advice from their attorney on the strengths and weaknesses of the association's case, how they should pursue the case, whether they should consider settling it, that type of discussion is also allowed in executive session, where everyone but the board members can be excluded. And then the final category is if the association is negotiating something, typically a contract. They don't necessarily want to discuss that in an open session with all the owners sitting around, because they may be talking about making offers to the other side, trying to change the terms of the contract, why they're trying to change the terms of the contract. They don't want that type of discussion to necessarily be shared with the owners and lead to the possibility that information that is not helpful to the association will either intentionally or inadvertently be released by the owners. So that's why the association is allowed to, the board, should I say, is allowed to limit discussion in executive session.
And so the reason why these topics, and they're listed in the statute, can only be discussed in executive session is because it's confidential, or the information in it, if it was released, it might affect some pending negotiations that haven't been completed.
Yeah.
Right?
Yes, that's the thing. I mean, that would be the reason, that the main reason.
So if this is confidential information, the board members that are in this meeting, can they discuss this information with other owners in the condominium project, or with their family members or their friends who don't live on I mean, can they discuss it outside of the board meeting, or should they discuss it outside the board meeting?
We would take the position that it should not be discussed outside of the executive session, because as we just talked about, the whole purpose of the executive session is confidentiality, not disclosing information that might harm the interests of the association. So if they leave the executive session having excluded all the owners and then go out and talk it with their family members or their friends, pretty much the whole purpose of the executive session is defeated. And so some boards actually have adopted policies about those kind of issues to bring home to all of the directors that executive session topics should be kept within the executive session, not discussed outside of the outside.
And that means to family members, to your spouse, and to your.
I would say even to your spouse, it would not be a good idea to discuss in any kind of detail what was discussed in executive session. And it doesn't put the burden on them to try and remember whether they should be talking about it to somebody else. If you don't tell them in the first place, they don't have to worry about maybe disclosing something. So that would be what we tell boards. If you're saying it has to be discussed in confidence, then you shouldn't be discussing it outside of an executive session.
Okay, and so who decides? Who decides what gets discussed in executive session? Is
Well,
it the board president
generally,
or is it
no,
the
I think
property manager?
generally it would be a board decision. They might get advice from, say, our office if it's our client as to whether, in fact, I just had a board meeting where one of the questions was there were some board members who had adverse interest to the association. The question was, how much about a committee dealing with those interests, how much of that should be discussed in a executive session of the board? And we said to the board members, this type of information you should limit. But generally, the board should be looking, and if they can reasonably say that it's personnel, litigation, negotiations, a proper topic, then the board would vote to move into executive session to discuss that. That would be the general way, but sometimes they would check with the attorney. Sometimes they would check with other people to see whether that is an appropriate topic for executive session. And again, executive session is limited to those attorney-client litigation personnel and negotiations that are ongoing negotiations.
Well, I have heard some concerns that, some boards, when they don't want the owners to hear about something, they'll just talk about it. They'll just say, "Oh, it's executive session, and we're going to discuss it there." What's wrong with that?
Well, again, the problem is that they are undermining the basic principle. I hate to keep repeating myself, of self-governance. If they can just exclude owners on a pretext, if what they're saying is executive session does not clearly fit within the four categories for which an executive session is allowed, they are violating the condominium law and they are undermining the purpose, because there may be things they don't want to talk about in front of the owners. But if they're making a decision that affects the association and it's not a topic for executive session, they are supposed to talk about that when owners who want to be present are present. So that is a bit of a problem. It is a temptation for boards to try and push the owners out and avoid the blowback from a discussion of something the owners may have concerns about, but that's not supposed to happen. So we tell boards that's the downside of serving on a board. Self-governance means the owners have to be there to keep an eye on.
Okay, to just give you an example, with this pandemic, the condominiums have not, many condominiums have not been able to have their annual meetings because, you can't have a gathering and there's
Yeah.
really nothing in their governing documents or the statute to allow them to do Zoom meetings like they do boards. Because with the board meetings, you have some authority in the statute that allows you to do meetings other than live meetings.
Yes.
And right now there are two bills in the legislature that will allow for digital annual meetings. But because we condominiums haven't been able to do annual meetings, I got a concern from a condominium owner that their board is talking about the continuation of the annual meeting in executive session, and they won't do it. And apparently somebody's talking about it because the homeowners found out about the fact that the board is talking about it in an executive session. And the issue is, how come they're doing that? And so shouldn't they be talking about that in the public part of the meeting?
Yes, it's a little hard to think what part of a decision to postpone the annual meeting or call it to order and adjourn, why that would have to be an executive session, because the background of that topic is pretty straightforward. It's the mechanics, the limits on gatherings. I don't think any of that would generally be considered to be a confidential issue, or the discussion of it would be considered to be confidential. There could be a few minor issues that might be considered attorney-client, but yes, it's a little hard to see why that topic of rescheduling or maybe postponing the annual meeting would be something that had to be discussed in executive session.
What advice would you give to an owner who came to you and with the concern that, my board won't discuss why they're postponing the annual meeting? They insist that they have to do it in executive session. I mean, what would you tell somebody who came with that concern?
Well, I do get calls from owners. I usually tell owners the best thing you could try to do is establish a paper trail. So rather than just complaining about it at the meeting, go home and write a letter to the board, maybe chair of the property manager, say, I'm very concerned that the board has expanded the topics in executive session beyond what the law says are the appropriate topics to be discussed in executive session. And sometimes I suggest to the owner that they ask the board to check with the association's attorney to determine whether what the board is saying is appropriate for executive session really is, and also to explain to the board that the purpose of executive session is a valid purpose. It's self-governance, it's the fundamental principle. So that would be one way of doing it. If that doesn't seem to have any effect, then the board continues on. As you know, there is mandatory mediation. Owners can push boards into mediation, and the advantage of mediation is you can try and get a skilled and informed mediator who will be an independent third party. And you would hope that you can convince the mediator so that he or she can convince the board that what they're doing is not consistent with the law. So those are some low-key approaches to trying to explain to the board that when they go beyond the limited scope of an executive session, they are not complying with the law, but it's their responsibility to comply with the law. And that's how they should try to address the issues. I don't know whether it's worth the time and expense of arbitration and litigation, but certainly raising the issue formally in writing, asking the board to check with the association attorney or even the property manager. That's one way. And again, mediation, there's a fairly comprehensive mediation program through the Hawaii Real Estate Commission that is mandatory that the owner can insist. And then they would be trying to get the mediator essentially to accept what they're saying, which is the board is not following the law.
And you brought up a good point when you talked about, the property manager, because another concern I have that I received is from a unit owner who says that, and we know this, the property managers have a lot of, what do you call it, influence with the boards that they serve.
Yeah.
And so a lot of, board members, including board presidents, rely on their property manager, for direction. And in this particular situation, apparently anything having to do with communications with the attorney, association attorney, is somehow assigned to executive session. So that means that if the board asks for a legal opinion, let's say they're amending house rules, and they send it to their attorney to review to see if they are in compliance with fair housing, with some of the language, the signs that are posted, and maybe with their rules about animals. And so it's and to this homeowner, that discussion should be in the public part of the meeting, because homeowners would be interested in hearing that discussion and maybe participating in it.
Yes, I'm not sure. Again, I would always like to start from the point of view that the board meeting should be open unless there's a valid reason why not. That would be a more gray area, because if, for example, the attorney sends something to the board saying your current house rules are in violation of fair housing laws because the provisions on animals, the provisions on reasonable accommodation, that's probably not something that the board would want to spread around the project, because that might encourage somebody to bring a claim. But So it's hard to tell, and there are a lot of reasons why what the attorney is telling the board is not something that should necessarily be shared outside. But simple things like if the discussion is about how the house rules are supposed to be adopted, and that's laid out in the bylaws, there doesn't seem to be any reason why an attorney and attorney advice on that issue would be a problem, because it's not really giving anything away. It's just telling the board, this is what your documents say you have to do when you adopt house rules. So that would be a little bit of a gray area, and it would probably, unfortunately, be like a case by case analysis of what the attorney is telling the board and whether it's just administrative type things, how to adopt house rules, as opposed to flaws in the house rules that might expose the association to liability and should be changed, because once they're changed, it's fine. And one of the things about executive session minutes, it does say they are to be kept confidential until the purpose of that confidentiality no longer applies. So that could apply in this situation too. Certain things might be confidential, but then they might cease to be confidential if, for example, a problem the attorney raises is corrected.
So if you're a board president and these issues come up, I mean, who do you consult? I mean, so you should be picking up the phone and calling the association's attorney and
Well,
saying, I've got these topics. I'm not really sure if it should be executive session.
I think that would be a reasonable thing to do, because it does involve legal issues, and it might involve, the type of background that the board members might not have. And possibly the property manager would be reluctant to weigh in on. Some property managers don't seem to mind giving legal advice. Others are reluctant. So I don't think that would be a problem, because it would be a fairly short and sweet question, just whether this is
Yeah.
appropriate.
Okay. In other words, if there's a question, they should be asking whether or not it should be an executive session. They should probably go to the association attorney rather than relying on the property manager.
Yes, I think that, and I think that would be fairer to the property manager, because many of them will say, hey, this is not our job to give you legal advice. And it can be a fairly short and quick call, because a lot of the topics don't require that much information. So it should be
Right.
okay. Yeah.
Well, we've kind of run out of time, and I know that we'll probably be addressing this issue again, because, like I
Yeah.
say, most of the questions we get are about board meetings and what the board is not doing or what the
Yeah.
board should be doing, and everybody's got an opinion, and because this is so important, I guess, to owners,
Yeah.
and the issue of self governance, I think we need to keep talking about it and addressing issues so
Yeah.
that, the owners get the full benefit of self-governance in their condominiums.
Yes, I think that's true. And I think unfortunately, board meetings are where the rubber hits the road and owners are directly involved in what's going on. And I think that it's a point of contention. But I think if the board starts from the basic principle that everything we do should be open to the owners unless there's a valid reason why it shouldn't, that makes life a little easier for the board too. And I think if their rules spell out appropriate controls on owner participation, it shouldn't really get out of hand.
Okay, well, thank you, John, for being on our
Okay.
show. And and I'm sure we're going to invite you back again when we have another topic where we need your expertise. Thank you so
Okay.
much for being
Yeah.
with us.
Thank you for
And I
inviting
want
me. I appreciate it. Bye.
And I want to thank the viewers for joining us for another episode of Condo Insider. It's the show about people who live and work in condos. And I hope you will join us next week. Raylene Tenno is going to be your co-host. And so please tune in next week, Thursday at 3 o'clock for another episode of Condo Insider. Mahalo.